What is the significance of them not travelling together at any time?
There's nothing special about it, but if you are in a married relationship, if you are leaving, going overseas and coming back, taking all these travels and holidays, it raises suspicion, isn't it?
Yes.
Whether there is a spousal relationship or not. Now, the answer would be very clear if I read this. On 6 of 11 overseas trips taken by the sponsor between 2007 and 2011, she travelled with, let's say, person X, it says David, to Thailand on 3 occasions, and to Europe, to Hawaii, and in 1 trip to Vietnam, while the applicant remained in Australia.
Obvious discrepancies.
And that has led to an adverse decision, and the tribunal was not also satisfied, so they affirmed the decision not to grant the visa, affirmed the decision of the department.
But one would suggest with modern technology that this kind of situation would be more prevalent today. So Skyping is more acceptable for a means of communication, of love, etc. I mean, online relationships are becoming more and more a part of our society, so this case seems a bit outdated in my opinion.
In a spouse visa application, the essential question that the case officer has to decide is, considering all the evidences, whether the parties has lived together in a continuous relationship to the mutual exclusion of all others, and that there is a genuine relationship. Well, in this instance, the tribunal as well as the immigration department has come to the conclusion, based on the facts, that it is not the case in this. So a genuine relationship was not established.
Dinesh, what other kind of difficulties can arise if you don't fill out your passenger card correctly? Say, for instance, you don't provide the correct occupation.
Yes, we've got a situation some time back. There was a issue in relation to an applicant's occupation. So at this time, in the most recent application, a client has noted a certain occupation. However, either someone has dobbed in, or however the departments are suspicious, and they've somehow retrieved a boarding pass, a passenger card that was done in 1970s. It was microchipped, and they found out certain information from those forms or the card, that a contradiction in relation to this particular case that I'm referring to, in relation to the occupation. So the client could not properly explain the difference. In fact, there were more evidence to suggest that the client has been fraudulent in this matter.
But what if you have more than one occupation? Do you have to disclose both, or is it just the one that you spend more time doing?
Remember Section 102 of the Act. You must disclose. So it's always better, it's common sense would dictate that just disclose whatever that is appropriate, not to omit anything that can come and bite you.
So Dinesh, what about volunteer positions or jobs?
Oh, you have to ask these questions. Anyway, volunteer positions, I would suggest to disclose, but under workplace laws, that may not be considered or cannot be considered as employment, because it is not employment for a pay. So it's actually not employment. So you have to read the question in the form or in the card or whatever you do, and answer the question appropriately.
So Dinesh, you've mentioned a lot about the giving of information to the departments and the relevant government departments, but what can the departments do with that information, and what are they authorised to do with it following your...
Yes, Migration Regulations 3.10 says, with the permission of the delegate, this information can be used by for other purposes, for example, intelligence, security, education, tax, social welfare. It's massive.
So what about those individuals who have a lot of privacy concerns? What can they do to protect their information?
In relation to law, if the law asks you to do something like in this case, to disclose that in the passenger card, you have to do that. Usually there are privacy guidelines within the government departments, and it's up to the government department to follow the privacy guidelines, and there would be, it is expected that those guidelines are followed.
So Dinesh, the second question received is from another viewer, and it's going to the spouse visa matters that you've already raised, he says, my partner's permanent spouse visa application was refused by the department and indicated that Section 5F of the Migration Act is not met, but they've been living together as partners for a long time now. He also says that the department says their evidence is not strong and is indirectly accusing them of providing information that is manipulated. Can you generally tell us what a person in this situation can do?
Yes, a person affected by a statutory decision is entitled to have the case determined by reference to found facts and not on suspicions or conflicts of evidence. So in this case, he may want to go back to the department to get it reviewed again and have a discussion, but the department might say a decision has been made, and to approach the Migration Review Tribunal and you only have a certain specific time period to go. So in this instance, it's not stated whether the time has passed or not, but you only got 21 days or 28 days, whatever, depending on that matter.
Yeah.